This is part 5 of evidence, concluding here with hearsay. Hearsay is a person's oral or written assertion at a time other than while testifying. This is also called an out-of-court statement. Now, the assertion may be oral or written, and it may be verbal or nonverbal. An example would be, my mother said she saw the accused at 3 p.m. This is generally inadmissible unless it is offered to prove something other than the truth of the matter asserted, such as his mother saw the accused at 3 p.m. Perhaps it is offered to show that the son spoke to the mother. A statement to declarant's mental state is not hearsay. Prior inconsistent statement is not hearsay. It's made under oath. This includes depositions. May be used for impeachment and as substantive evidence. Prior consistent statements are not hearsay. Again, this is prior consistent statements, not hearsay, if they're made under oath or not under oath. However, they must be made before the declarant had a reason to lie. And this can be used to show truth in the testimony. A prior statement of identification is not hearsay. This can be prior ID of a person in a lineup. This may be substantive evidence. In an action where the plaintiff and the defendant are in an action, the opposing party's statements are not hearsay. And this can be in the context of a judicial admission, an adoptive admission, or a vicarious statement. A judicial admission is a statement made by a party to the current litigation that's not hearsay if offered by the opposing party. A statement by the plaintiff offered by the defendant against the plaintiff. An adoptive admission is where a party hears a statement, such as Brent killed so-and-so, and Brent is silent, where a reasonable person would have denied that. That's an adoptive admission. A vicarious statement is a statement that is imputed to another based on a relationship, such as an employee and or an agent or authorized speaker. Now, there are exceptions to the hearsay rule that hearsay is generally inadmissible, and these exceptions are that the declarant is unavailable, or that the statements are admissible because they are inherently trustworthy. Now, where the declarant is unavailable, they may be unavailable due to privilege, because they refuse to testify, because they lack memory, they have passed, they're dead, they're infirm, or they are generally absent and the court cannot produce them. Looking at where the witness is unavailable, former testimony of the unavailable witness is not hearsay if the party it is offered against had an opportunity and or motive to develop the testimony on direct and or cross-exam. And that does not mean direct or cross-exam of that unavailable witness, but if they've had an opportunity to develop that same testimony on direct or cross, the prior testimony of the unavailable witness will not be hearsay so long as they have. Again, where the witness is unavailable, a dying declaration is not hearsay if the person making the statement believes that death is imminent and the statement pertains to cause and or circumstances of death. Again, where the witness is unavailable, statements against their own interest are not hearsay. This makes sense. Why would you make a statement against your interest unless it was true? This is a statement against the declarant's interests at the time it was made. Not later, but at the time it was made, and a reasonable person would not have made that statement unless they believe it to be true. Now, where the statements are or may be hearsay, but they are admissible not because the witness is unavailable, but because the statements are inherently trustworthy. And again, here the availability of the witness is immaterial. This is a present sense impression, is not hearsay. This is a statement describing an event while and or immediately after it has been perceived. This is an excited utterance, again, immaterial that the witness is unavailable. This is not hearsay. This is a statement made while the declarant is under the stress or excitement of the event. And again, those two indicate that generally people wouldn't have the capacity to think up a lie in those instances, so those are generally admissible. They're generally trustworthy. Discussing the state of mind of an unavailable witness. It doesn't matter that they're unavailable. This is not hearsay. This is a statement of the present intent, motive, and or plan, and this is used to prove conduct in conformity. Physical condition. It is immaterial that the witness is unavailable. This is not hearsay. This is a statement to the physical condition. This is where physical condition is at issue. This is a statement of feeling pain, general health. This is used to prove existence of a condition but not cause thereof. A statement made for medical diagnosis and or treatment is not hearsay. It's irrelevant that the witness is unavailable. This is describing a medical history, past and or present symptoms. And these statements may be made to medical personnel other than the physician, and or it may be made also to family members. A recorded recollection is not hearsay. It's immaterial that the witness is unavailable. This is where a record exists on a matter that the witness once knew about. It was made and or adopted by the witness when the matter was fresh, and it accurately reflects the witness's knowledge. And after consulting the record, the witness states they cannot recall events well enough to testify. Business records are not hearsay. It's irrelevant that the witness is unavailable. These are records that are part of the record-keeping part of the business activity, and the record was made at the time of the activity by someone with knowledge of the activity. Example would be a police report. However, in police reports, the report itself would fall here as a hearsay exception, but statements made by witnesses in the report do not. Those would still be hearsay. They would not be cleared from being hearsay under this exception. Constitutional limits on hearsay. The Sixth Amendment and the Confrontation Clause. In a criminal trial, a declarant must be unavailable, and the defendant must have had an opportunity to cross-examine the declarant for their hearsay statements to be admissible. That's from Crawford in regards to the Confrontation Clause. Constitutional limits on hearsay in the 14th Amendment, the Due Process Clause. The 14th Amendment may prevent hearsay rule when the rule unduly restricts the defendant's ability to mount the defense, and that's from Chamber. That concludes Part 5 and all of evidence.